10 o'clock and to have your ballot count, you have to have it in by now. So if you haven't done so, please go.
I'll yell out. We need your ballots in. If you haven't turned your ballot in yet, it has to be turned in now for it to count. So if you haven't turned your ballot in, please do so. It's going to be about another 30 to 40 minutes before the counting is completed. And but I think we're going to start the meeting in a few minutes. So again, if you haven't turned your ballot in, please do so now.
No, just turn your ballots in.
Can you hear me? Barely? Can you hear me better like this?
Yeah.
That's technology for you. Thank you all for coming today. Just a brief note, there are some sign-up sheets here for various committees that we're going to try next year to help the board respond to the concerns of the community. And there are 4 sign-up sheets up here. Nobody signed the landscaping sheet. That doesn't mean you have to do the work. Okay. But we've had some discussion about revamping the CC&Rs. The CC&Rs were created when the community was first established, and there are some things that need some refinement. So that is one of the sign-up sheets. Also, we want to look at the security in the refuge, and as well the guard shack on the north entrance. And like I said, the landscape, if you want to be involved in some ideas with the landscaping. And also the design review committee, if you have any desire to be part of the design review committee, that's a very important committee for the HOA. And people come and go off of that committee, depending on their personal schedules and what they've got going on. So if you would like to participate with the design review committee, if a spot becomes open, you can sign that as well. So these will be up here when the meeting's over. If you have any desire, go ahead and sign up. That'd be great. At this point, I want to do a roll call of the board. Do I do that, or do they do that?
If everybody just says their name, that'll work.
Okay.
Ray Powell,
Brian Thenis,
John Ball.
Dick Miller,
Ron Boys.
Okay. There's a copy of the 2014 annual meeting minutes attached to this agenda. And if I could have a motion to accept those minutes.
I make a motion to accept those minutes.
Okay, we have a motion to accept. All in favor?
Need a second.
Oh, we need a second.
that's second.
Second. All in favor?
Aye.
Aye.
Let's clarify, the vote was 5-0?
5-0. Okay. Ron Moyse is going to review the 2014 financial statements.
Thank you. Starting off with the balance sheet. Hello, I'm Ron, by the way. Thank you all for coming. Starting with the balance sheet, the $11,000 is obviously Wells Fargo. That's money we got in the checking account. Compliance, if you want to read it line by line. Compliance, that's the people that are building that give a deposit. Wells, that's $271,000, which will also be down in the liability side. Reserves, $49,649. That's what we have in our reserves, which we're working on. Then under the liabilities, again, it's pretty self-explanatory. Prepaid dues, $19,000. Compliance deposits, that's the building deposits, $184,000. Total of $80,000 there, $283 total, which is up at the top and under the asset side also. I think the main thing to look at on there is that we've got 48,000 in a reserve, which, you know, we've really got to work on. Then going to the P&L, it's pretty self-explanatory too. Between the different incomes, the association dues and the design review committee, the monies that we bring in we brought in $439,000. The administrative expenses were $298,000, repair and maintenance $114,000, utilities $18,000, for a total of $430,000, which means we ended up with an ordinary income of $8,500.
First time in a long time.
Hurrah!
And then capital.
Yeah, and then of course, your other income and expenses, your capital expenses, your drainage, that was the big hit for the water, $120,000. Interior gate, $7,200, and painting, $970. So, you know, we had to hit that 120 out of the reserve, but it's, you know, it is what it is there. Any questions?
I got a question. Dave Steele, lot 313. Under your balance sheet, we have prepaid dues of $19,000. Is that in one of these accounts up above in the asset?
It's a cash basis report.
Where's
So,
the 19,000?
what do you mean?
It's got in an account someplace. So there's
Oh, you mean you're
data-
saying that the checking account should be 19,000, or should be 19,000?
Basically, we're under the assets is that 19,000 part of us.
They're on the balance sheet.
Amy's up and paid like for a year.
Yeah, people that prepay.
But if we got the money.
Yeah.
Hey Dave, I think I could probably answer that for you.
Yes.
If somebody's prepaid their dues, say they've paid a year in advance, okay, that money comes in, goes into the checking account, and it gets dispersed for expenses.
Yeah, we could have taken in 19 but spent 27 that month or that year. So that's the amount that's in. What I have to do, because you guys have cash basis reports, there really isn't an accounts receivable. I have to make an adjustment each month to take out what's in accounts receivable and put it into prepaid dues. So it's just an accounting journal entry, but we could have 19,000 in prepaid dues, but spent more than that as well, because it's a balance sheet, it's not part of the P&L.
Jeff Jennings has got a question. You mentioned that the reserves are less than what we want them. What is the target? What would be the best case or the desired reserve?
Well, everyone has an opinion. You know, we'd sure like to see it, you know, substantially more than that. Substantially more than that.
Ron, the study you guys paid for said it's supposed to be 405,000.
I'm sorry?
The study you paid for 3 years ago, you know, the study you did
Yeah,
on,
yeah.
it's supposed to be 405,000.
It didn't account for the drainage, though.
Yeah.
Drainage wasn't in it.
Yeah, well, the 120 grand, we took a pretty big hit on. But listen, we're not disagreeing with you. We agree with you. We've got to get the reserves up.
He asked about a plan. If you look on the budget, we do have 127,000 planned to go into reserves this year. That is our target, that is our goal. I did already transfer 5,000 in. So that's the goal, if that answers your question. You just tell me that.
Thank you.
Do I have a motion to accept the 2014 financials? Do we need a motion for that?
Yep, we should.
A motion to accept the budget.
Do you
No,
have a
not the
second?
budget, not the budget. We
Not
already
the
did
budget.
that the last meeting. It's the year-end financial statements.
I make a motion to okay the financial for 2014.
Dick, you want a second?
I second it.
All in favor?
Aye.
Amy, you want to bring us up to date on the never-ending weed problem?
Yes, weeds are becoming a huge, huge problem. I want to first of all thank everybody that did a tremendous job this last year. I would go out there and come back with a huge stack and go back in 30 days, and the stack wasn't all gone, but a majority of you guys did take care of your lots, not only once, but many times throughout the year. It's getting bad again. In the next couple weeks, more violation notices are going to go out for weeds. So if any of you guys are here from out of town, maybe just take a peek at your lot before you go. We strongly recommend the pre-emergent. It is expensive initially, but somebody comes out there every 6 months, sprays the pre-emergent down. It kills all the seeds, so you don't ever have weeds. And it is my understanding if for some reason we have a heavy rain and weeds do pop up, they come out for free and pull them or spray them. So if you look at all the times it costs to clear your lot, it does pay for itself in the end, and then you don't have to worry about it, and I don't have to worry about it, and it's a win-win. So I would like to encourage everybody to consider the pre-emergent. One thing that has come up here recently for the first time is I'm getting complaints about wrought iron fences getting rusted, falling apart. Neighbors don't want to tattle on their neighbors, and if a fence is brought to my attention, it usually is pretty obvious who called. So I am going to be going around and checking wrought iron fences and sending out violations for that, and it will be what I observe. I don't see everything every time, so if somebody does want to bring one to my attention, please feel free to do so. But that might be something you guys can check onto in your yards, and maybe a little bit of sanding and touch-up paint will solve that. But it'll be one thing that'll help make the community better. So that will be added this year to the violations that I look for.
Okay, thanks, Amy. They're still counting ballots, so I'm going to have Brian give us an update on the legal situation right now.
Well, I'd like to thank everybody who's supported me in my efforts.
Speak up, please, Brian.
I'd like to thank everybody who's supported me in my efforts to manage this lawsuit. I do find that I'm the manager of it with the legal team. It hasn't been easy. You know, I run a pretty good-sized civil engineering company. I got 65 employees. We did 29 million square feet last year, and it takes up a lot of my time. And I do devote a lot of my time to go back and forth and work with the attorneys. I've been to numerous hearings. I testified for 2 days straight in the trial. We won the trial. We pretty much won everything we were looking for. You know, this has been a difficult situation, I realize, for this community. There's a lot of confusing information out there. It is a very complex matter. In fact, that's what the judge said. He said in all the years of his trial, this is the most complex trial. Judge Jansen in Mojave County said this is the most complex trial that he's ever seen. And I understand how that could be very confusing to people on the outside looking in, and there's a mountain of documents to review, and I could see why it would be so complicated to understand. And I think, you know, there's been some question as to whether or not it was the homeowners association's responsibility to file a lawsuit. I realize this isn't a complete legal update, but I think a lot of people are a little bit in the dark as to what was done and why it was done. And I want to bring some clarity to that. You know, the association had no choice in filing the lawsuit. And the association had to seek judicial construction. You know, it is an egregious action to tear up the golf course. In my mind, it's my absolute firm belief that it was the intent, and it was the stated intent in the beginning, to sell off individual parcels. And I believe that if that were to happen, to sell off individual parcels, and the RV park or the golf course, or both were to fail, the next guy in line, the next developer in line would say, well, you know, we got trailer parks on one side of the road, let's just have them go right up and down the golf course. And I believe that that would have been the ultimate destiny of this community. I strongly believe that. I don't believe the golf course could survive as a whatever it is now. It's not a real golf course. The CC&Rs, the sole purpose of the CC&Rs were, and this is a recital in the CC&Rs, declarant deems it desirable to establish covenants, conditions, and restrictions for the purpose of enhancing and protecting the value, desirability, attractiveness of the property, and enhancing the quality of life within the property. And the former association took action on September, I wasn't a member of the board at the time, but on September 24th, 2010, before I became a board member, Jill Marshall signed a resolution to hire an attorney to oppose the development of the golf course property. The intimidation by the Aldridges, it kept everybody paralyzed. It put the association's attorneys in fear of making a mistake and becoming liable for doing something that would come back and haunt them. And I believe that the intimidation factor accelerated through the discovery process with City Center's attorneys and us. They made a mistake. They just made a mistake. Section 2.2 is kind of the story of what happened, right? Section 2.2, declarant makes no representations or warranties whatsoever, this is the CC&Rs, that the project will be completed in accordance with the plans for the project as they exist at the date the declaration was recorded. Any property subject to this declaration will be committed to or to be developed for a particular use or for any use. Any property now subject to this declaration will be subject to the provisions hereof, that they cannot guarantee that the property won't be changed in the future. Well, Jerry looked at this and said, wow, I can do whatever I want with the golf course. What they failed to realize is that section 1.42 says project or property. That's the definition of the word project or property. It means real property described in Exhibit A, blah, blah, blah. The property shall not, underlined, include the golf club facilities or any other property. Whoops. Whoops. And I think that the intimidation paralyzed the board. It paralyzed the association's attorneys' ability to react quickly. They are homeowners association's attorneys. They don't state that they have a lot of land use experience, a law trial experience. The association needed to seek the opinion, of a land use specialist. And before I became involved, they hired B.S. Gilbert to write a letter or to review the facts. They had a community meeting, everybody was invited, and they basically wrote the board and said, I think this is when Lloyd Hightower was on the board, to date our clients have individually borne the responsibility and expense of investigating the rights of the refuge community and opposing City Center's effort to redevelop the golf course. Blah, blah, blah. We therefore demand on behalf of our clients that the board take such actions as reasonably necessary to oppose City Center's conversion of any portion of the golf course for any use other than a golf course. And then that's why this resolution was signed by Jill Marshall to hire an attorney to oppose the RV park. It just didn't happen. It wasn't happening. So I filed my lawsuit. I filed my lawsuit shortly after this, or I filed the plaintiff lawsuit, and the board had always represented to our clients that, or to the attorneys, that they were going to take over the lawsuit. Eventually, on December 15th of 2011, the association joined the lawsuit. The association intervened and joined the lawsuit in December of 2011. Ron talks about this cost-sharing agreement, which was signed. It was dated December 15th, 2011, and signed April 10th, 2013. It just took a long time for the association to figure out how to make this happen. It literally took over a year to get the association to officially take over the lawsuit. It finally did. It finally made an adoption of this lawsuit on April 10th, 2013, just a few days before the trial. Just a few days before the trial, and believe me, the attorneys were telling us, we quit. We're done. We're done. We're not moving forward unless the association's behind this lawsuit. We were within a week of trial and finally got this cost-sharing agreement signed. We voted in an open meeting, and this is a resolution posted on the website that says that John Ball and I recuse themselves, that Ron Moyes signed the legal representation agreement, signed the cost-sharing agreement, signed and approved the conflict waiver. You know, he signed everything. He signed all the contracts that hired the attorneys. What he thinks he did, he thinks he pulled a fast one on the attorneys. He thinks he limited the liability to the lawsuit. Here's a cost-sharing agreement that was executed by the board, which is a 11-page time and materials contract.
Is this the legal update, or is this just throwing it
What are you
out?
doing? What are you doing?
I need to-
Yeah, we're gonna go on to that.
It sounds like you're rehashing everything instead of a
Can you
legal
talk
update.
about the lawsuit, not about alleging wrongdoing by a colleague?
Jesus.
Please.
Why don't you just get a stick and beat me, Brian?
That would be nice.
Why don't you show him Exhibit B right now, Brian?
I will.
Good, go
Okay.
show it to him.
So now that's not this is the legal update, by the way. There's a lot of confusion as to the responsibility of the association. There is. And we've been trying very hard.
Are you going to pass out Exhibit B or not, Brian?
I'm not
Pass it
allowed.
out.
Mr. Moyes, could you please have some decorum? Could you guys please have some decorum? That would be fantastic.
I think there's a lot of people that don't know what's going on. So for those of you who don't know what's going on, I'm reading these documents, and at the end of this speech, I will give you the attorneys' phone numbers. You guys have the right to call the attorneys, to go to Phoenix and review the documents. Okay?
Brian, you know the attorney's not going to talk to us. Why do you ignore that issue?
They will.
Oh, yes.
Okay.
Yeah, what is Exhibit B?
Exhibit B here, Exhibit B. Exhibit B, there is an 11-page time and materials contract that this is on a time basis. If it wasn't on a time basis, Ron, first of all, the association would have no right to seek compensation for $2 million. They had no right to do that. Do you think the lawyers are going to commit fraud? How are the lawyers going to do that?
I thought you said you were going to show him Exhibit B, Brian. Are you going to do that or not?
Client's
That's what we
obligation-
agreed to, Exhibit B. So
I'm
you're going
gonna
to show
read
it to him or not? You said you
I can't show
was.
it to everybody.
Well, show it to him.
Well, you can come up and read it. Yeah.
Ron, tell us what it is.
What's the synopsis of it?
Client's
I can't or
obligations,
he'll sue me, but let's him. I won't sue
client's
him.
obligations to pay fees billed from and after the effective date. In other words, that's December 2011. This is the funny thing about Ron's theory, the hilarious part about Ron's theory. 2011, fees were incurred from 2011 as well as prior thereto. Prior to 2011, I paid those, by the way. Thank you. And how we pay those prior to fees is defined and conditioned in Exhibit B. And Exhibit B basically states that there was payments made by me, $274,000, $761.81. And then there's an unpaid balance. This is funny though. So there's the unpaid balance of $600,000 prior to the execution of this contract. So between 2011 and the signed date of this contract were bills incurred during that time, which the association did not sign this agreement, was $600,000, and the attorneys agreed to take payments at $10,000 a month to pay off that balance. It also says here, if we lose, we don't pay anything. Pretty damn good deal. So ask yourself, does it make sense? Does it make sense for a law firm to agree? Does it make sense for a law firm to agree that they're going to go forward with a 3-week trial, that they're going to pay for flights, for depositions, for legal counsel, and there were 7 of them there for 3 weeks? Does it make sense that they would agree to prosecute the lawsuit, that they would agree to defend us to the highest court that would accept jurisdiction? This contract says that they have to take this lawsuit through the Court of Appeals and to a new trial. They agreed. They're going to do a new trial. They're going to go through the Court of Appeals and the Arizona Supreme Court if necessary. Would any self-respecting law firm sign an agreement that says they're going to do that for free?
Read the next paragraph, the other performance clause.
What Ron thinks he did.
Read the next performance clause.
Hey guys, come on.
Yeah, well, come on. Don't just give them half the page, give them the whole page.
Well, here's the risk here. Here's the risk here. We thought the same thing. We thought, John and I sought legal advice independent of this. We thought, wow, we didn't know about it. We didn't sign it. We weren't a part of this agreement.
Who signed that agreement, Brian?
Dick Miller. Ron Moyes and Dick Miller negotiated this agreement. Our Ekmark demanded, and Richard Basinger demanded that John and I recuse ourselves from any discussions regarding the cost-sharing agreement. They claimed there was a conflict. B.S. Gilbert said there was no conflict. I don't think there's a conflict. Most of the people in this room want the RV park gone, so I don't understand how that's a conflict. How is that a conflict? I don't understand that.
Is this $600,000 you owe or HOA owed?
Well, that's the funny thing, right? So what this $600,000 is about is how do we pay the fees that were incurred before this agreement was executed? So honestly, if anybody had any debate, the $600,000 would have been fees that the association didn't directly at the time formally agree to pay. They agreed to pay them after the fact. There was a lot of value in that. We got Hankinson, the original developer. We went to wherever he lives, Wisconsin, to get his deposition. We got the deposition of the original county employees who worked on the project that said they did put a conservation easement on that property, only to go in and get deposition. We got their affidavit, their sworn signed affidavit. We deposed them. They got redeposed, and they said, "Whoa, wait a minute, we didn't mean that." So somebody got to them. We got to them first, and we got the evidence we needed from the county that proved that there was a conservation over the golf course. But Ron wants something for nothing, and you know what you get when you want something for nothing? You get nothing. You know, does anybody know who Lovelock is? Lovelock is a son-in-law of somebody at B.S. Gilbert's law firm. When all this started, his name started popping up on all the correspondence. And I'm thinking, why is it popping up on the correspondence? You know what Lovelock does? Lovelock picks me up at the airport. Leblock drives me to the B.S. Gilbert's office. He's like my driver for the attorneys. He passed the bar the 5th time. 5th time. He just got his license. He will be our attorney.
Nobody has a deal.
Just hear him out.
Do we owe $600,000 a month?
Yes.
Yes.
Is it your 600,000?
Whoa,
No.
that's not my opinion.
What does the document say?
What about the money after?
That's not my opinion.
After 2013? And how come
If-
the HOA members didn't vote on this?
Let me finish, and you can ask me all the questions you want later on. We have an open mic after this. Everybody gets 2 minutes to talk and ask me all the questions you want. I've got all the documents. You can walk up here. I'll read it through with you, but I can't let it go. It has to stay in my possession. I'm sorry. That is what the lawyers told me, but they said I could talk about it.
Then talk about it.
I'm trying. We have a time and materials contract. We have a time and materials contract to reimburse the attorneys for all their expenses. To date, it's about $2 million total, not 600 plus 2 million. It's about $2 million. We don't owe that money. We don't owe a penny of that money. Jerry and Cindy Aldridge, personally, we made sure that the jury personally made them liable to pay back those legal fees. We have a long way to go to collect those fees. I'm going to just finish and then we'll do the questions in a more formal manner. We have a long way to go. We have to get through the Court of Appeals. When they are obligated to pay back 100% of the attorney's fees, we made sure that the jury had instructions to make them personally liable, not City Center, not one of their shell corporations, but personally liable to pay back the attorney's fees, and they are personally liable. The attorneys know, and this is why I don't get this, the attorneys know we can't pay them. The attorneys know all we can do is give them whatever monthly payments we can afford. They worked for 1.5 years without being paid. They're a well-capitalized, very strong law firm. We picked the right law firm for the covenants part of this lawsuit. There were 2 lawsuits. The association was sued by City Center for blocking the roads for the construction of their swimming pool. They won most of that. They won that case. But that case had to do with rights of easements, the use of the easements, and it was mainly a defense. They were hired by the attorney company, hired by the insurance company to defend the association, not to seek judicial construction of the covenant and agreement to maintain the property as a golf course. The other lawsuit, the second lawsuit being the covenant case, the one we're talking about with the cost sharing agreement with B.S. Gilbert, that's the case that confirmed the conservation easement exists over the golf course. They saved this community. They did a great job, and I don't know why we would want to screw them. I have no idea. I have no idea why we'd want to screw them right now in the Court of Appeals. That makes no sense. Why do we want to piss off our attorneys? This is not the time to negotiate the cost of the lawsuit. That time will come. It will certainly come. They'll have to settle. We'll negotiate. We'll find a way to make it fair and equitable and affordable for this community. But to go to battle right now with the attorneys, who saved this community, is just simply irresponsible. They will walk away. They will. They will. They can. And if they don't, Lovelock will be our attorney. We'll have Lovelock working for us, because I would do that. Why wouldn't they? I don't know, why wouldn't they just throw the lowest guy on the totem pole at this lawsuit if they're not going to get paid? So, anyway,
State of the appeal.
yeah, thank you. Now, I think I got everything. All right, state of appeals. All of the documentation is in. There were numerous filings. If you stack the filings up in the Court of Appeals, it'd be probably that tall. There was an amicus brief done by some bogus attorney that's in Arizona that states that, he states the same argument. The mistake that Aldridge made on his amended complaint. He cited section 2.2 that says he can do whatever he wants with the property. This amicus brief made the same mistakes, stated the same argument. That argument, they can do whatever they want with the property, was stated 19 times in their amended brief. But we had to file a motion and more paperwork. And I don't think for free, Ron. I just don't think so.
When's the date for the appeal?
So all of the briefs are in. Finally, there were. I think there were probably at least 15 filings. There was the Chuck Elias fiasco. That was fun. We had Chuck Elias, the security guard, go to Judge Jansen and said he lied on the stage or he lied on the stand, and I want to throw out my testimony. And we were worried that the judge could say, "Wow, we have a mistrial." And luckily, he was smart enough to say Chuck Elias is a disgruntled employee. That his testimony is basically irrelevant because it only had to do with the security, and since it's not even supposed to be there, luckily he saw it right the way it should have. But that could have been a disaster, and it doesn't surprise me from Chuck though. I mean, I know a lot of people know Chuck, but if you've read some of the emails to
When is
Amy,
the date of the appeal?
so why it's taking so long?
No, when is the date?
We don't know.
It's April 21st. There's a meeting April 21st.
April 21st, we've reset the, April 21st is the oral argument. We were afraid that, we were concerned, we weren't sure if the judges were just going to do a summary judgment ruling. But now there's an oral argument. I think it was the 24th, but
Could be 21st.
yeah. Oh, we'll get that date, and anybody that wants to attend can attend. And watch Franklin in action. He's cool. He's 72. He hasn't lost. He's only lost one case in 10 years at B.S. Gilbert's office, and he's an amazing man. And it would be. I look forward to watching him speak. So how long it takes after that, I don't know. And what the results will be, I don't know. And I know this is a trying, difficult situation. I know that it seems, it seems like maybe we should give up. That's kind of what the sense I'm getting is a lot of people think we should give up. But once we win this lawsuit, we'll have an action against the county for allowing the construction. They should not have allowed that because our lawsuit says, not that there is now a conservation easement, but the lawsuit says there has always been a conservation easement over the golf course. The plat map clearly states it. It's labeled on the plat map, golf course. The use of the property is A through E is for golf course. We will have an action against the county.
But Brian, didn't you guys already sue the county and lose all the way to the appellate?
No, we withdrew. We actually withdrew. We weren't getting the cost sharing agreement signed in time, and the attorneys were ready to back out, and they came to me and said, we want to drop the lawsuit with the county. We never should have done that. Never should have done that. And if we had got that cost sharing agreement signed earlier, then we'd be in better shape. But there's a room full of people here, okay, who were not plaintiffs in that lawsuit. And any one person, we need a person, not an object, not an association, not a corporation, a person to say, the county shouldn't have put me through this. And that would open the door back up to the county. We don't believe the door is closed with the county. We just need to win this lawsuit first.
When you said that you pledged your net worth, I was at several meetings when you said that you would pledge your net worth to this. So if you were so supportive of this lawsuit and you were the originator, how come you're not supporting it now when you want to split it all amongst us?
I could just die. That's also a metaphor.
So you were not telling the truth? You really don't support the lawsuit with your net worth, as you stated numerous times?
Well, I think it's pretty ridiculous to expect one homeowner to fund that lawsuit. So why are you asking that question?
Because he said it.
Well, so it's a ridiculous question?
It's a ridiculous statement.
It's a ridiculous question
I
as
agree.
well?
I agree.
Okay, well,
But if somebody says something, and we're supposed to trust you as a board member, if he says something that is filmed and is recorded, so we know that he said it, how can I believe anything he says now, because he's standing up there now?
well, it's all the documents.
It doesn't matter, he says that.
Well, you can choose to believe him or not. That's
A
your
reasonable person-
decision.
You know, it is,
Fireworks going off in the parking lot, you guys,
Oh my
get back to the meeting, please. I love you, my husband, but let's go.
that's insane. All right, so we, just to close up on the legal update, the Court of Appeals
We're almost done, Brian, just keep going.
just one person just to think that I should just pay for everything, do all the work, is just so absurd. So absurd. I'm sorry. The Court of Appeals has to rule that the judges conclusion of law or any of the procedures during the trial were defective. They can't say, we disagree with the judge without due cause. They have to find a procedural error. They have to find a conflict in law. We had a mountain of attorneys reviewing everything. We feel good about the appeal. We feel very strongly about the appeal. I want to keep our attorneys happy in case we do have to retry this case. We want the same team. We want the same effort from our lawyers. We will do everything it takes at the conclusion of this to restore the cash reserves through seeking compensation from somebody, the title company. There's a title flaw. We put them on notice in the beginning, so they know they've got a potential claim. They denied coverage, and that's what we wanted. We didn't want to be defended by a title insurance lawyer. And so we know that B.S. Gilbert is not going to wait 75 years to get paid for this. They're going to find a way to get it out of the county or get it out of the title company, or they'll have to wait forever. But you got to understand, the cost of this lawsuit is just peanuts compared to the destruction of the community and the lost value of properties. It had to be done. I'm sorry that there are people who think that it's my responsibility. That's offensive, I'm sorry. But it had to be done, okay? And we expect a result within a couple of months. Could be a month, could be 2 months, could be 6 months, could be a year after the oral arguments. So we won't know anything until a few months after the April hearing. So that's where we stand. And thank you very much for your time, and thank you for those of you who support me.
It's very, very close. Still in
The votes are very close, so they're going to double check the tally. We'll have an announcement here in just a few minutes. We're now going to have an open forum. Anybody can speak for 2 minutes. Since we don't have a microphone, if you want, you can stand up and say what you have to say. And it's an open floor at this point.
I'd like to say something.
Okay. When you
I'm Dave Seaver, lot 313. I'd like to have in the future a little bit more detail on our minutes. It seems like every year we have these open forums, we all get up and talk, we make an opinion about this or that, but it shows up in the minutes that the board accepted comments from the floor. I'd like to see a little bit more information where somebody questions somebody and we get an answer back. Maybe I'll say something further. I'll reserve my next minute and a half.
I cede my time to you, Dave.
Anybody else?
I've got a question. So with regards to...
Excuse me, you need to say who you are and your address or your lot.
Okay, Jeff Jennings, 3662 North Winifred. So my question is relative to the 2 million. I'm just trying to seek to understand. Sorry? So my question is regarding the 2 million. So I understand from what Brian said is that there's 2 million that's out there in terms of legal fees. If we win, we don't owe that the Aldridges do. I think that's what I heard. Is that correct?
Yes.
Okay. So what happens if we do lose? And I understand we have high confidence, but if we lose, who owes that? We do. And how will that be paid for? And then the second thing is, how much do we expect in further further legal fees to be throughout the rest of the process?
Well, I can answer your second question first. I mean, that really depends on how long the appeal goes for additional fees. And ultimately, the agreement that was signed and voted on by the board, the ultimate responsibility for the legal bills are the HOA.
That's, of course, John's opinion, and we have different opinions about that. He reads the agreement different than I read the agreement. Well, I have to be very careful what I say because I know Brian is Sue crazy, so I have to be very careful what I say. But in my opinion, the agreement that we fought back and forth with, which is why Dick and I are the bad guys, is because we were worried about the community having to pay. And so we come up with a very, very good plan with performance clauses in it to protect the homeowners. Now, Brian can stand up and say what he wants, but he just found out that he lost, so he's a bad loser and walks out. But, so the problem is, I see it different than John and Brian see it. And that doesn't mean that John and Brian are right and I'm wrong, or that I'm right and they're wrong. We've all been around major litigation, and there's 25 different ways to read a contract, right? In my opinion, we have extremely strong performance clauses, and I can't get into depth. I tried to get him to explain that to you. Miller and I spent a long time being screamed at by these guys to come up with an agreement. We came up with an agreement that protected the homeowners. In our opinion, it has extremely strong performance clauses, and that will be taken care of. Obviously, we'll have, and how it was determined was also negotiated, meaning that there was going to be an arbitrator. We wouldn't take it to court, and we feel like, because people don't know my background, but I've been around court and lawsuits a lot. Unfortunately, not proud of it, but I feel I have to, I can only speak for myself, but I feel very good about explaining Exhibit B that they won't let me talk about in front of a retired judge, which is who it would be in front of in arbitration. So to answer your question, I feel really good about it. There's some performance clauses in there that that are very beneficial, and so far Buse-Gilbert hasn't triggered those performance clauses. Did that answer your question?
Yes, thank you.
So much.
Stand up, please.
Young Garnett, Lot 251, and I was wondering, how legal is it for a board to vote another board member's legal fees to pay them? I mean, doesn't that mean we could all put our bills in there for legal fees that we have?
I think the point is that the board originally voted to join the lawsuit. That was one instance where the board voted to join the suit. Almost 2 years later, the board voted on a plan to pay for the lawsuit. Do you follow that? So that they voted to join the lawsuit, then right before the trial, they voted to pay for the lawsuit.
But it's a conflict of interest for you, the board members there, to vote and pay another board member's bill.
Well, but I
Because we
think,
have no vote on it.
I think what you're missing though is that the HOA had joined the lawsuit, so it was the HOA's bill.
Well, the board members joined the lawsuit. Why don't you put it to the congregation?
Yes.
Well,
It should have been.
you know what, if I had a time machine, we could all rewind and go back 2 or 3 years, but we can't. Okay, we can't do that. So this is what we have. We have,
It should have been a majority vote.
well, shoulda, coulda, woulda, okay? We had, well,
The HOA should.
we won the lawsuit. Why would we stop?
You guys all know.
Enough is when the Court of Appeals rules.
Do you know the definition of enough? I do.
Well, that's your opinion, and you're welcome
No, it's
to
not
it.
an opinion, it's a statement and a fact.
Okay. Well, why don't you stand up and say who you are?
I'm Lori McGraw, Lot 101, and you know who I am. And it's enough. I'm very quiet all the time, but it's enough. You don't have to keep going. Nobody does. It's your choice. It's a choice. This choice. Not everyone in this audience is choice. That's the point you are missing. That's what John was trying to tell you.
Catherine DePaul, Lot 081. I attended the first meet and greet that was at the Bracamani's home, and I questioned Brian regarding these costs, and his exact word was he assumed that the association would pay this legal fee. And I know there are other people in the room who heard him say that.
Well, the association agreed to pay.
The association had agreed to pay, and then those started wrapping.
3 board members.
Well, the board members are elected, excuse me. The board members are elected by the HOA, and in the CC&Rs, the duties of the board members are very clear. So if you don't think that the board members should be able to be involved in lawsuits on behalf of the HOA, then you might want to get on a committee to change the CC&Rs, because that's the way it is. I'm sorry, that's just the way it is. If you don't like it, then try to do something to change it.
But again,
Yes, ma'am.
this is where Mr. Ball and me disagree. Graciously to Mr. Ball, our attorney that wrote up these papers we're talking about happens to agree with shall I say, my side, and that he does not agree that we owe all of that. And that's the danger of electing, to be quite honest with you, not to be argumentative at all, but we know it's all boils down to Exhibit B, and when you're in arbitration, it's the intent, okay? There's a big boilerplate, but it's all about intent, and the exhibits usually supersede the boilerplate. So, and the other team here said that we joined the lawsuits in 11. Well, we did join the lawsuit, but not financially. We didn't do that till later. And we joined the lawsuit, but not financially. So we did join it financially later with performance clauses and caps. And that's where Mr. Ball and Mr. Thames and Mr. Miller and I disagree. And that will obviously go to arbitration. But in my opinion, the way I stand right now, I don't believe the homeowners are liable, in my opinion, And everybody has an ASS and an opinion, right? But in my opinion, we're done in 3 more months. But again, I can't talk about it because I'm worried about people that just left the room suing my butt. And you know, Mr. Brian, I don't want to talk while he's gone, so I'll use Mr. Ball. They talk about suing the county. Do we understand what happens when we sue someone? We're in another 6-year litigation against their insurance carrier. Who wants to put up another $3 billion? I mean, this thing is ludicrous, what is going on, and the sales pitch that these plaintiffs that started this lawsuit are trying to pitch to you people is just absurd. And it's not, I'm not being argumentative, I'm just simply stating my simple opinion.
Okay. Yes, ma'am.
Yeah, Elaine Roberts, Lot 40. I'm just curious about the Exhibit B. He's worried about being sued by it. Brian has it, but only read part of it. Is that because it's his lawsuit, so therefore Exhibit B belongs to him and not to we property owners that he wants us to pay for? Why is it he can't reveal that to us and wants us to call the lawyer, which means more dollars up? So I'd be interested in knowing why he won't expose that to us.
Good point, Elaine. So he wants all of us to call the attorney and charge us $350 an hour.
Can you answer that, John?
What is it?
I'm sorry?
Can you answer her question?
Why can't we have a copy of it?
Because it's attorney-client privilege.
And so who's is the client us, or is the client Brian?
It's nuts.
Well, if you, I think Brian made it pretty clear. If you want to call the attorneys, they can explain it. Maybe
don't call the
they'll.
attorney, it'll cost us more money.
Okay, well. Okay. Tom?
Tom Graybill, 3424 Patrol. Seems like we're spending a lot of time talking about these legal fees as if the HOA was going to have to pay them. Don't we have a judgment?
Yes.
I mean, when did this judgment get overturned? I don't know how you can make an assumption. I don't know how you can make an assumption that the Aldridges are not going to pay this judgment. We have a judgment.
We have a judgment.
They have to pay it.
You were on the board, Tom. You know that Mr. Aldridge, first of all, we don't have a judgment. It's got to go through appeal, and then it's got to go through the Arizona Supreme Court. I'm 66. I may not see the end of this, okay? It could take years for that. You know that, Mr. Graybill. Number two, you also know Mr. Graybill. And by the way, Mr. Graybill is a very good man, and I'm a personal friend of his. However, just because we disagree on a couple of issues, Mr. Graybill knows up front, we're never going to get a penny from Mr. Aldridge. A penny, even if we did get a judgment, which we don't have a judgment. We don't have a judgment, it's in appeal. It's in appeal. It's in appeal court. And then it'll go to the Arizona Supreme Court.
It's still a judgment.
But you can't pick it.
Right, once they lose the appeal, it still has to act on the.
Who says they're going to lose the appeal? You have a crystal ball? I don't.
There's no mistake about this. These homeowners who had 3-week civil jury trial in Kingman won flat out with, have you guys ever seen 12 Angry Men? You know that, whatever it was, whatever the guy, right, the Ford movie. We had 12 angry grandmas who all decided through complex evidence presentation, depositions, oh my God. And we had 12 very angry grandmas who, watching them turn from week 1 to week 3 to understand what the hell was going on at the refuge. This is property they don't own, they don't live, they don't care about. This was their civil duty, and they understood it. So you guys need to just calm down. Jerry chose to take this to appeal. That's all. That was his choice.
Do you think we'll ever collect from it?
We're going to be done by Christmas because we are having a big party.
Do you think we'll ever?
They'll have the money to pay you, right? You'll be able to collect on that?
Absolutely.
Good luck on that one.
Absolutely. Because he's got good investments.
I'm not an investor. There's more misinformation.
My name is Mario Panico, Lot 163. I'd like to paraphrase a letter I sent to the board, and Brian and I have had an exchange the last few days. You know, as a homeowner, I don't mind being complimented or screwed, but I like to know about it. And so the letter states that it is apparent that the campaigns of Bert Roberts and Ron Moyes did open up a lot of communication from these candidates, that stuff that would have remained secret to the homeowners. I believe that Brian had a conflict of interest. He disagrees, I disagree. You know what you call those people when they disagree? Defendants and plaintiffs. I'm not going to get into that. John Ball might remember years ago when someone in his team said, this is going to be done and over in a matter of months because it's been settled. I told Mr. Ball, there's attorneys that have a saying. In a major lawsuit that is costly, the first party that comes to their senses is going to lose. If you understand that, so when someone finally has no more money, they say enough is enough. I think where they misguided their direction is they didn't keep us informed. All of a sudden they're trying to come out and say, we've done this, roads, floods. Did any of you ever get an announcement for an open meeting? Have we seen minutes? No. Even on the website that they so said we're going to keep everyone informed? No. So they have no one to blame but themselves for not keeping us informed. Yes, we elected the current board. You need to wake up, and at some point it's going to be too late. Remember the city of Bell in Los Angeles? Everyone was asleep until all of a sudden the LA Times brought an article. Up until then, everyone would say, there's no conflict of interest. Trust me, I'm the city manager. Thank you.
Morgan Shields, 3582 North Winifred Way. What kind of procedures can get put in place to avoid this in the future? I'm just a little horrified that with the size of the amount of money that's being involved and the actions that have been taken, that there wasn't more voting or members involved, some kind of forum. What can be put in place to keep this kind of activity from happening? Change the CCNRs.
Well, if you want to have some input into changing CCNRs, I would say that's probably a logical step towards that. But this process has been going on for 5 years. Okay, and there was a lot of input from homeowners. There were an election every year for 5 years. And the different board members during that time were elected by the HOA members. If the members didn't feel that that person that was elected to the board was a good representation in this legal situation that we've had basically since October of 2009, okay, then I really don't have a good answer for you, because it's up to the people in the room and it's up to the voters. And the voters didn't want to live on an RV park. 400 spaces was the initial 400. Have you ever been to a 400 space RV park? That is what we would be living around. And if everybody's happy with a 400 space RV park?
Thank you very much. But what I'm bringing up, and I'm bringing it to everyone's attention, start thinking about maybe approaching this in a different manner or coming up with a procedure so that this event does not happen in the same way again. Thank you.
I just have one more thing on Elaine Roberts, Lot 40. I'd like to ask. I know you guys have a mandatory number of board meetings that you have to have, and I understand maybe they're not all here in town, but it would seem to me that a good board would get together, have a meeting, announce when it is, and let all your constituents come to those meetings and hear what actually happens at those meetings. Is there a way that that can be done?
Well,
Arizona revised statutes allows the board to discuss legal matters in executive session without anybody being present.
But not every meeting is executive session. You must have other things to talk about.
We had an open meeting to raise the dues.
Well, when you have meetings and you talk about something other than the lawsuit.
It really isn't right. Unfortunately, the lawsuit does consume the board right now. And most of the board's actions have related to the lawsuit. So pretty much everything has been, what do we do next? What's our next course of action? You know, do we hire this attorney to get this recorded, filed? It's all been, unfortunately, a very consuming endeavor for this board to deal with the lawsuit. And we cannot have an open meeting to discuss legal strategy. Doesn't make sense.
Don?
Just as a follow-up, we had some disagreement about not the judgment, but whether or not Aldridge was going to be able to pay the judgment. But we haven't really touched on the bond. He's also been required to put up a bond, and that's going to be heard in that hearing on April 24th. So
25% of the amount.
Well, it's $600,000.
And he hasn't put it up.
And if he doesn't put it up, what happens?
Gary?
Gary Charlevoix, lot 0600. My concern is that we're all homeowners, we all pay our dues. Part of our dues goes to protecting the community. I believe in what's been trying to get accomplished the last several years. There's a party that owns a number of lots in the refuge. I don't believe they're here today, but the thing is I don't think they're up to date on their dues, which would help to pay off some of the legal fees. And also, I'd just like to see in this audience today, can we see the people who have invested with these people and find out, because it's a conflict of interest. How can you be a homeowner, pay your homeowner's dues, and then invest in a person who's trying to ruin your community? So, with the people who have invested, you know, in that project, pardon me?
Let's see the B thing first.
What now?
You don't see conflict of interest, the plans being on the board, no conflict of interest there?
You know, one of the things that I do see is the fact that I do believe in the client-attorney privilege. And I do believe, how many times has Mr. Moy said today that he's worried about being sued because Brian's sued happy? You know, I really look at this community. You've heard me say this before. I want us all to unite again. Yes. And one of the things you've heard here, we voted this board in. If you don't like this board, we may see a change of the board today. But the fact is that how can you sit here, bitch about your dues and what's happening on the board when you're an investor trying to ruin what we've all paid into when we bought our houses 5, 6, 7, 8 years ago, or 10 years ago.
Are we there? Kimberly Leparn, 3604 Winfred Way. My question is, since you guys feel confident, which, okay, either way, I'd just like to see the lawsuit end and everybody move on. I have not heard anything about what goes on after you win the lawsuit, or we win the lawsuit. What happens then? What's the plan?
Why don't you tell us?
She's asking you.
I have no idea. I have no idea. I've been asking that for years. Somebody show me a plan. Well, okay, so Aldridges are out of business. Golf course is closed. We win. There's no judgment. Golf course goes into foreclosure. Bank gets it, sells it to somebody else. Is that? And do we have a plan to, as an association? No, that's
scenario.
It's a scenario.
Please answer the question.
I'm asking the president. I'm not asking you.
Not a board.
You're not a board member. You're not a board
We can't talk about it because it's not property that we own.
I don't think it makes any sense to speculate what's going to happen in the future to the golf course. Now, I'll let you say what you have to say. To the golf course, to the Aldridges. Who knows? Who knows whether they'll pay? Who knows whether the bank will sell it to someone else? Nobody knows that right now as we sit here today. So it's really kind of pointless to speculate on it. But what?
No, but in a business plan, if you have a business plan, you have contingencies, and if you file a lawsuit, you should say, okay, if A happens, this is what we're going to do as a board to protect our community, and if B happens, this is what we're going to do to protect our community.
That's how you run any business.
Right, isn't that common sense?
There are hundreds of scenarios with the disposition of the golf course. It could go fallow.
It could go what?
Fallow. You know, weeds grow, dust, nothing. Yeah, that's right. But I think it's better than an RV park.
Wait a minute. Oh, you guys in this room are telling me you want a 400-space RV park?
I'd rather have it than weeds, yeah.
Well, you would, Ben. I can understand that, but for the majority of you people,
The golf course has, the golf course is an asset.
It's
The
ridiculous.
first thing, it has a clubhouse. The golf course has a clubhouse. It has an Arnold Palmer signature golf course on the property. The first thing we needed to do was establish that it can't be anything other than a golf course. Now after that, hopefully, the Aldridges restore the golf course. I actually heard that he was talking about doing that. Restore the golf course back to an Arnold Palmer signature golf course, or back to a full-size golf course. Somebody will have to deal with it, whether it's the association, whether it's Jerry Aldridge, whether it's a future owner. One thing's for certain, that it will have to be a golf course if it's anything. That's the first step. Trying to speculate who does what in the future is impossible because there's too many scenarios. But the first thing we had to decide is what's our playing field? What is it supposed to be? Is it supposed to be a water slide, a motocross track, a go-kart track, a hotel, a motel? It has to be a golf course. And then it's up to the golf course owner to figure out how to survive. It's not our responsibility.
yes, sir.
Marcel, there's only lot 71. Is there any compromise with Jerry? I'm just asking. I'd rather than laying weeds.
I personally have never heard Jerry offer to compromise on anything.
Jerry
That's
has
just me.
never spoken to anybody who opposed him. Never. I have not had, in the beginning, I did. He wanted to convince me his plan was a great idea. I told him, Jerry, I have to oppose you. I can't let it happen. Not one RV spot. Huh?
Rich Ayers did. Well, you guys got him because he could go there with another board member. Call him.
I don't
You
know.
know why you got rid of Rich Ayers?
I don't know what you're talking about.
That was before you were on the board.
Yeah, I wasn't
He,
there.
and Rich did not run. That's why he's
I
not
got
on
the
the
history of
board.
all these things, Ryan. You should know all that.
I don't know what two other people talked
I
about.
went to the Winter Fest.
You've already spoken, man. That's enough. One more time. Vote me off. Or do whatever you want. She's spoken 3 times. She's supposed to be up once.
This is insane.
Say it. Say 5 seconds.
I went to the Winterfest last weekend. Jerry was there talking about the motorhome sites that he has in place and some condos right in front of it.
So now we get condos and
Yeah.
Do you favor that idea?
No, I'm not. But I saw what he was advertising. Thank you.
One more, as property owners, if there is a new board, hopefully, they just approved the minutes of a year ago. Does it take that long in all these secret meetings for the board to have met and sent out minutes within a reasonable period of time, a few days, a week? That tells a lot about, do we need procedures, standards to tell the board to do that as their first fiduciary duty? Of course not. They just wanted to hide everything. So hopefully the new board members will take that into consideration, keep us informed. Again, give us compliments, screw us, but keep us informed.
Do we have the results, John? Of the election?
There's a 5.
You know, a lot of us have been here from the beginning for 10 years, and I just want to thank this current board because I know that a lot of you are new property owners and you have no clue to what we went through and what we were promised in the beginning. And it's like the new people come on and they don't recognize the work and the toil and the sadness when there were going to be mobile homes in my front yard. And we've fought to keep those mobile homes off and motorhomes. And I just hope that you guys understand what's transpired over these 10 years and what we were told in the beginning, a lot of you missed. And you've missed the emotion, and you've missed the loss, and you didn't miss the property, your property values didn't go down like ours did. And we've helped you. You guys are going to come in, the new people, and you're going to enjoy the appreciation because of the hard work that this board has done. And I don't think any of you guys respect or have the gratitude that you should have for all the work that they've done for us. Thank you.
I have a response as well. Dave Seaver, Lot 313. I have been here as long as you have. And there has never been a meeting, ever, since this board or since Jerry's taken over the golf course, that we have not, talk about respect. It's us that didn't always agree with you guys, that we were shouted down, that we were insulted. That I had that guy tell me one time at a board, can't that old man shut up? I had Bob Ballard said, I've had enough of your shit, sit down. There has been disrespect against everybody here that went against this board and what they were trying to do. I never had a thing against the lawsuits. You guys can sue the hell out of everybody you want. Brian, sue me if you want. You get nothing, but you can sue me. But I don't think it's my responsibility to pay for your problem. And you're the guys that have the problem, not me. And you're going to shut me up now, John?
First of all, I apologize if I said that. I don't think I did, but I'm old and forgot. May have forgotten. You sure that was me?
It was about 4 years ago.
I apologize.
We're just waiting. They're just waiting for the ballot. So.
It's getting close. We could tell.
No, let's just wait.
I was going to say, it's close and then recount.
Because you know what's going to happen if we go the other way.
All right, the ballots were counted twice, and this is the final results. Phil Bracamani had 129. Ron Moyes had 124. Burt Roberts had 123. And Brian Thenis had 121. Based on those votes, Ron and Phil Bracamani have been voted onto the board. There's also, people have requested a tally sheet of people who voted and didn't vote. Those will be made available and along with the votes. So the vote count, I'll repeat it again. Phil Bracamani, 129, he had the most. Second one was Ron Moyes with 124. Burt Roberts with 123. And Brian Thenis with 121.
All right, thank you, everybody that voted. Do I have a motion to adjourn? Okay. Do I have a second?